Hello everyone and welcome to today's Mondac webinar in association with BCL Solicitors LLP, who will provide valuable insights into the Economic Crime and Corporate Transparency Act of 2023 and how business professionals can stay ahead of the changes and remain compliant. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. John Binns is a specialist in proceeds of crime laws, sanctions and tax investigations. He has extensive experience in financial crime, which also involves bribery and corruption, extradition, Interpol, fraud, market abuse, and the conduct of related civil proceedings. He is a prolific writer and speaker on a variety of topics. Anushka Warlow specialises in acting for individuals and companies in relation to all aspects of financial crime, principally cases involving complex allegations of fraud, bribery and corruption. Anushka's expertise in fraud and financial crime is recognised by both the Chamber's HNW and Legal 500 directories. Shula De Jersey is a partner specialising in business crime and regulation. She's ranked in Band 2 for financial crime and Band 3 for financial crime high net worth individuals by Chambers and Partners. A leading individual in Legal 500's fraud, white collar crime, is recognised as a recommended lawyer in Who's Who Legal, Investigations and Best Lawyers Fraud. Tom McNeil is a partner specialising in business crime and regulation. Tom advises corporates and individuals in relation to the most complex and high-profile investigations and prosecutions involving fraud, bribery, money laundering, environmental crime, corporate manslaughter and safety offences. Now, before I hand over to the panel to begin today's webinar, a quick housekeeping item. You are able to submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and we'll endeavour to answer as many of your questions during our Q&A session and throughout. It's now my pleasure to hand you over to our panel to begin. Thank you.
Thanks, Dan. Good morning and welcome everyone to our webinar. For those of you who don't know, BCL Solicitors specialises in domestic and international corporate crime, financial crime, regulatory enforcement and serious and general crime. We provide expert advice to a diverse portfolio of clients, including corporations, public figures, senior executives and individuals. In today's webinar, we'll be focusing on one very significant development in the landscape of corporate criminal liability, the new offence of failure to prevent fraud, which will come into force in just 3 months' time. Today we plan to talk you through the background to that offence, how it works, who it applies to, what companies should be thinking about now from a compliance perspective, and perhaps most importantly, what corporate entities might do if they uncover fraud within the organisation. My name is Anushka. I'm joined by my colleagues John, Shula and Tom. You've heard their expertise set out, and so you'll agree this promises to be a very informative session. I have a very easy job of asking the questions, but as Dan has just said, we also want to hear your questions. We've had some of them in advance today, which we'll try to answer at the end. But anything else, please do put it in the chat box and we'll try to get to it. That's enough from me. We can jump in, and as ever, the sensible place to start is the beginning. So the new failure to prevent fraud offence is a significant addition to the prosecutorial toolkit. It's been talked about for a long time. Successive directors of the SFO have been calling for an offence of this nature for years, as have others in law enforcement. So Shula, perhaps you could talk us through that background and how we've got to this point.
Thanks, Anushka. So of course, corporates in themselves cannot think or act. It is their members, employees or directors that do so. But corporates are separate legal entities and therefore can commit a criminal offence. Successfully prosecuting large corporates in the UK has had many challenges, which has led to a concern that the UK has fallen behind in tackling corporate crime, largely due to difficulties in relation to the identification principle, namely the need for an individual who was considered the controlling mind of the corporate to be guilty of the offence in order for the corporate to be guilty. A significant development in corporate crime was seen with the introduction of the Bribery Act 2010, which came into force in July 2011. Section 7 of that Act introduced a new corporate offence of failing to prevent bribery. It applies where someone associated with the organisation bribes someone. It is an offence of strict liability and applies even if it had in place adequate procedures, applies even if the organisation itself was not aware of the bribery. The company has a defence if it can show that it had in place adequate procedures to prevent bribery. Since the introduction of the Section 7 offence, the SFO has charged and successfully prosecuted, by way of a deferred prosecution agreement, which I'm going to come on to, a guilty plea or conviction by jury, a total of 12 organisations for failure to prevent bribery. Deferred prosecution agreements, which are known as DPAs, is a US model, and they were introduced through the Crime and Courts Act 2013 and came into force in March 2014, some 3 years after the introduction of the failure to prevent bribery offence. DPAs are available only to corporates and are a non-conviction based mechanism. They are essentially an agreement between a prosecutor and a corporate entity, which allows for the suspension of that entity's prosecution for a particular economic crime offence for a defined period of time, provided that the corporate complies with certain obligations. Those obligations generally will include the payment of a financial penalty, compensation, disgorgement of profits, payment of costs, continued cooperation with the prosecutor, and a corporate renewal programme. Included within that agreement will be a statement of facts relating to the offence, which sets out the basis upon which the corporate accepts criminal culpability. A DPA can only take effect if it is approved by a judge as being both in the interests of justice and having terms which are fair, reasonable and proportionate. If the company does not meet its obligations under the DPA, the agreement can be revoked and it can be prosecuted. Key to a DPA is the voluntary cooperation of the corporate with the prosecutor. So in essence, DPAs are a commercial negotiation between the corporate and the prosecutor, with the benefit of the corporate being avoiding the expense and reputational damage and litigation risk of a conviction, with the associated risk of being barred from tendering for public procurement contracts. Since their introduction in 2014, there have been a total of 13 DPAs, 12 of which with the Serious Fraud Office, 1 with the Crown Prosecution Service. The DPAs that have been entered into with the SFO have yielded 1.7 billion in fines and disgorgement. The DPA entered into with the CPS yielded 615 million. As I've already touched upon, successfully prosecuting large corporates for economic crime outside of the Section 7 offence has had significant challenges because of the need to identify a guilty controlling mind. This is very starkly demonstrated by the high-profile collapse of the SFO prosecution of Barclays Bank in 2018. The bank and a number of its senior executives, which included the CFO and the CEO, were prosecuted for conspiracy to defraud relating to an investment secured by Barclays from Qatari investors. The court rejected the SFO's position that the senior executives of Barclays who were being prosecuted could be the directing mind and will of Barclays, because although they occupied very senior positions, they did not have the authority of the company to conclude the relevant agreements. The powers which they had exercised had been entrusted to the board of directors, and therefore those senior executives did not have the full discretion to act independently. That case led to the government in 2020 tasking the Law Commission to undertake a detailed review of corporate criminal liability in respect of economic crime. Their report was published in June 2022, and it set out a number of options, including amending the identification doctrine, as well as the expansion of the failure to prevent offence. Hence, the Economic Crime and Corporate Transparency Act 2023 introduced 2 of those reforms. The first is the widening of the identification principle so as to attribute corporate criminal liability where a senior manager of that corporate commits a specified economic crime whilst acting with the actual or apparent authority of the corporate. This change is designed to make it easier to hold companies accountable for economic crime, and it came into force on the 26th of December 2023. The second, which is the reason why we're here today, is the introduction of a failure to prevent fraud offence, which comes into force on the 1st of September.
That is a perfect link to the next bit. So we know as part of the sort of process that led up to today that there was a lot of back and forth in the draft versions of the legislation in relation to this new offence. But it is here now in its final form. And John, perhaps could you sort of set out the architecture of that offence and who's it applying to and how?
Yeah. The basic structure of the offence is familiar. It'll be familiar to anybody who knows the Section 7 offence in the Bribery Act, which should have mentioned. And it's essentially that if an associate of the company commits an offence, then with the specified offence, then the corporate is guilty unless it can show, in this case, that it had reasonable procedures, which is pretty much the same as adequate procedures in this context, or in this case, it can show that it was reasonable not to have procedures at all. So, and just as in the Bribery Act, associates is more than just employees. It can be people who are engaged, perhaps on an informal basis, and it can be a written contract by the corporate to perform specific functions or specific services on its behalf. So what's different between the Bribery Act offence and this one is, first of all, what offences are involved, second of all, where they can take place, and third, who the offence applies to. So the self-evidently, we're not talking about bribery here, we're talking about fraud. The offences that the associate would have to be guilty of are listed in the schedule to the Act, and they include cheating the revenue, which we may come back to later on, sort of kind of fraud to do with tax evasion, and the main offences under the Fraud Act, which break down into misrepresentation, failure to provide relevant information, and abuse of position. So one of those offences is committed by an associate, then the corporate has a problem, and there's a few sort of miscellaneous offences as well in the mix. Where is an important question and different to the Bribery Act, because what matters for this purpose is where the associate commits their offence. If there's a majority of the acts that constitute the offence take place in the UK, then that gives the corporate a problem, even if the corporate isn't actually incorporated here, and even if the corporate doesn't generally do business in the UK. It's where the associate is that matters. And finally, who. So this is not, and this is one of the things that was debated at length in Parliament as the bill went through, this doesn't apply to all companies. It applies to large organisations and to subsidiaries of large organisations. And the definition of a large organisation is hidden away in section 201. You need to tick at least two out of three boxes. That's about having a turnover of over £36 million, a balance sheet that's over £18 million, and or an employee headcount of over 250. Interestingly, that's about the figures that apply in the financial year of the corporate preceding the offence. There's a bit of a potential time lag. If you're not currently a large organisation, but you're on the way to becoming one, then you need to have your house in order and have the procedures that we'll come to in a second in place by the end of that financial year, because it will effectively bite beginning the next one. Conversely, it can cease to apply, but with that time lag in the year after, you cease to become a large organisation. So there's subtlety there, and there's the basics.
Exactly. It's right also that the associate needs to intend to benefit the
association. So it's an offence for the benefit of the company. In some circumstances, it can also be for the benefit of the customers of the company, if that's what the associate is doing, supplying to the customer. And specifically, there's a carve out that if the corporate itself is to be a victim of the fraud, then that doesn't count. So it's a particular kind of, and I've heard it described as, interestingly, outward fraud as opposed to inward fraud. So companies will be used to considering frauds that are committed against them and have procedures to stop that happening. This is fraud outwards, as it were, for the benefit of the company and the detriment of somebody else.
So picking up on sort of the starting point there, which was there's a defence here, there's a defence for the organisation to have in place these reasonable procedures, these outward-looking procedures now, to prevent fraud. We know that the standard of proof there is the balance of probabilities, and it's going to be a matter for the court to determine if it gets that far, or in exceptional circumstances that it was reasonable not to have those procedures. But this is the crux of it, and this is the crucial part for companies. The government has produced some guidance on the topic, but the big question, I suppose, for all our clients and people watching is what's going to be a reasonable procedure? And that I'm going to ask Tom to deal with that because he's got views.
The short answer is that no one knows what our reasonable procedures will have regard to the guidance. The guidance, however, is principles based and extremely thin. Perhaps, in my view, the most important statement is, I quote, even strict compliance with the guidance will not necessarily amount to having reasonable procedures. Ultimately, that is a question for the courts, taking into account the facts and circumstances of the case. So a company can spend enormous amounts of time, money, and energy complying with the guidance, but for reasons that we will discuss, it may well be that that is never enough to get a defence. In theory, the requirement is for reasonable procedures rather than foolproof ones. However, if serious fraud is established, particularly over more than a short period, the inevitable assumption will be that the company's procedures were not good enough, and it'd be very difficult to rely upon the defence.
I suppose for now, I mean, companies, that might be the case later, but now the idea is that you do try to put in procedures that do work. And so what can organisations be doing and thinking about now in terms of trying to do the best they can?
Yeah, well, the point about it is it depends on the company. The failure to prevent fraud guidance, like all previous failure to prevent fraud, failure to prevent guidance is based around the 6 principles. What I want to do now is pick out some principles and make some comments to give a flavour of the kind of issues that companies will face. The first principle is top-level commitment. So in short, that means setting the tone from the top by one route or another, making it clear to the troops that fraud is a no-no. So directors, senior managers, partners. There's an interesting line, which is that senior managers and so on, quote, should foster a culture within the organisation in which fraud is never acceptable. A culture in which fraud is never acceptable. Culture is a word we'll come back to, but in my view, that can translate as, if you have significant fraud in your business, the view from law authorities and the courts will be that yours was a company with a culture which permitted fraud, and therefore it would be very, very difficult to rely upon the defence. The second principle is risk assessment. So again, the failure to prevent model is a regulatory model. At the heart of all such models is a risk assessment. So what is your business? In deep, meaningful terms, how does your business operate? And then applying to that deep understanding of your business, what actually is fraud? There's a bunch of problems around that. But what I'm going to flag in this talk is the issue around the test for dishonesty. So dishonesty is at its heart fraud is at its heart a dishonesty offence. There used to be an objective and a subjective limb. The courts have in recent years knocked off the subjective limb. It now no longer matters whether a person thinks what they are doing is dishonest. What you have to apply is the standards of ordinary, decent people. And importantly, you cannot apply the standards of a particular market or industry. So I'm going to quote the Court of Appeal in Tom Hayes, which is a liable case. So quote, the history of the markets have shown that from time to time, markets adopt patterns of behaviour which are dishonest by the standards of honest and reasonable people. In such cases, the market has simply abandoned ordinary standards of honesty. So the standards of ordinary, decent people, not the market. So if you're conducting a risk assessment and you think to yourself, well, this looks a bit like fraud to me, if the answer is, well, don't worry about it, that's how we do things around here, that's how the industry works, well, I think you might have a problem there. And in actual fact, that might be a reason why your risk assessment doesn't spot serious, significant, potentially long-term fraud and doesn't implement procedures to prevent that fraud. So the law as it now stands means that the market practice is relevant to a defendant's state of knowledge. However, an individual can commit a fraud offence even if he believed his conduct was legitimate and indeed consistent with market practice, provided a jury thinks it is dishonest, applying the standards of ordinary, decent people. So,
what do you know, Tom?
Yeah, yeah.
There's something a bit Kafkaesque about this, isn't there? Because it is, on the one hand, you're right to say that the guidance is thin in the sense that it's not actually practically useful in many ways. I mean, there's some exceptions, I suppose, but there's lots of statements of high principle. But this idea that there'll be a cultural shift and the standards of the industry and maybe the standards of the corporate themselves are going to be replaced with this new test for dishonesty, objective, based on what the man of the Clapham Omnibus thinks, is tricky to put in practice, isn't it?
well, yes, the short answer is yes. And so if you're on that particular issue about identifying a fraud when you have a market practice which may itself be fraudulent, how do you go about doing that? Well, first of all, you need to understand actually in detail how your business operates. Secondly, you need to understand fraud. But I mean, if you have a problem, if you're looking at your systems and you're thinking, this seems a bit fraudy, but we're doing it, is it okay? The short answer is you need to bring in, I think, independent views to assess what you're doing. There's a wider issue about how to change a whole culture of a business, and I just think it's extraordinarily difficult. What you've got here is 43 pages of principles-based approach. You've got people are coming up with new ideas. You have some learning going back to the Bribery Act, have some learning going back prior to that. But what you're trying to do is, on the basis of a short bit of guidance, change a cultural shift in the business where it's largely left to the companies to work out what it is they're supposed to do. You compare that to other areas. So this is a regulatory offence. Compare that to environment, compare it to safety. What you have in those industries is literally 100+ years of learning. You have extensive guidance running to thousands of pages. You have guidance which says, if you comply with the guidance, you'll be complying with the law. This guidance is 43 pages, and complying with it doesn't give you a defence. It's just a wholly different world.
I suppose what we need is, I mean, with the regulatory offences, they've existed for much longer, and so there's been this build-up of guidance over the years. And it might be that we're at the very start of the failure to prevent fraud, and we're going to grow it. And maybe we can come back to how sort of this failure to prevent fraud works with the regulatory sphere and how it might grow. But should we finish off your 6 principles and then sort of circle back, because those are really interesting points about culture and how to build those procedures that might be viewed as reasonable later.
Yes, so that was risk assessment. I'm going to skip through a few of them and go to communication. That's really about training and about whistleblowing. Both are really important. The point I'm going to flag here is within training. And so in my view, it's essential that training learned had reference to behavioural science. And so how people make sense of and interact with the world is not necessarily how you think that happens. People make a number of decisions intuitively. People have all sorts of biases. They make mistakes. They have a poor foresight, and a system in place which doesn't recognise and account for how people interact with the world is not going to be a very effective system, in my view. Fundamentally, people are social animals, so people have a natural predisposition to believe one another, particularly those whom they know and trust, and even those who, if they don't know, who look and sound the part. So it's very, very difficult to have a system which picks up and spots fraud when that works against people's natural instincts, and so you need to deal with that in your training. If we come back to, we might come back to the Burning Man, for example, how that was very difficult to spot, even for trained investigators who were told it was a fraud. And so the issue about behavioural science feeds into monitoring and review, which is the 6th principle, and the last one which I'm going to talk about. So the first one, fraud offence, applies to large organisations. It may be that for many of those that they spend time, money, and energy putting in place procedures, and the issue which they'll face is, are those procedures going to be actually applied in practice? I think the best way of flagging the issue with that is to give an example. The example I'm going to give is that of the Airbus DPA for first-rate bribery offences, but the principles apply directly, in my view, to the fraud offence. So I'm going to summarise it as shortly as I can. So first-rate bribery took place between 2011 and 2015. Note, most of the misconduct involved third parties, so intermediaries, agents. In 2012, so that's a short time after the alleged offending began, Airbus commissioned an external consultant to review its compliance programme, and Airbus received an award for the design of its anti-bribery compliance programme. So this is stuff which looks great on paper. Throughout, Airbus had written policies governing payments and contractual relationships with third parties, including policies specifically aimed at ensuring that third parties were used appropriately and only after sufficient due diligence. Airbus had a series of committees with responsibility for reviewing the use of and payments to third parties. In 2014, Airbus found breaches of its policies. They reviewed their systems, improved their systems, froze payments. A couple of years later on, there were inquiries by an external party, and Airbus self-reported. So what was the issue here? The issue was that some committee members were aware of and or involved in the material wrongdoing. The information provided to the committees was incomplete, misleading or inaccurate, such that the committees were not able to provide effective or properly informed oversight in the manner intended. And the conduct by some included the creation of false invoices, false payments and other compliance materials. So what you have is you have thoroughly dishonest individuals using sophisticated methods, including the creation of false documentation to deliberately circumvent company procedures. Some within the company might have turned a blind eye. The company then spotted the issue, stopped the payments, improved the systems. To some degree at least, it might be thought that the company systems were working as intended. And the view of the court was quite different. The company was fined almost £1 billion in the UK alone, 3.6 billion globally. The individuals, by the way, who allegedly committed these crimes walked away scot-free. So how did the judge who dealt with the DPA view it? Dame Victoria Sharp said this: as I have identified, Airbus did have bribery prevention policies and procedures in place at the material time. However, prior to September 2014, these policies and procedures were easily bypassed or breached, and there existed a corporate culture which permitted bribery by Airbus business partners and or employees throughout the world. So again, we have this corporate culture giving a pass to fraud. So the lesson here is that companies' systems will be judged on their outcome. If fraud is discovered, the procedures will be viewed with the benefit of hindsight. With the benefit of hindsight, there will be red flags, that will be stuff that wasn't done that should have been done. People will have not done what they're supposed to be done. People will make mistakes. Your systems will rely upon people. People are fallible. Your systems will break down. And if you have serious fraud, you're going to have a serious difficulty defending yourself. And in actual fact, I think in many circumstances, the easier way to defend may be to challenge whether or not it was a fraud in the first place, if the facts permit, rather than relying upon this defence.
I'm just going to say, for sort of good order, the two principles that you haven't dealt with are proportionate risk-based fraud prevention procedures and also due diligence, which we can sort of say something about, we can skip over for now. But I also wonder whether we should take the question that's come in, because it fits really nicely here, which is, would the judgment of the ordinary decent man vary depending on what's acceptable behaviour within the industry context? And that's a really good question. It goes exactly to what you were saying in terms of culture and how to identify something by the standards of the ordinary man.
That's a short answer, I think.
It's a short answer, it's going to be no, but would the judgment of the ordinary decent man vary depending on what is acceptable behaviour within the industry?
No, so the industry context is relevant factor background, but it doesn't go to the dishonesty test. There isn't a separate test of dishonesty for a particular industry. And if the man going to or from Clapham thinks that what you're doing is crooked, I'm afraid you're stuffed.
You just have to know what the man going to and from Clapham thinks of your industry.
Yeah.
But going to
They're going through Clapham, or they might be going to.
from Clapham.
Anyway, never mind.
I'm going to pick up on your final, deliberate circumvention to one side. Assuming that a company has in place its monitoring and its review procedures, those procedures are in part going to be designed to detect breaches. And assuming those procedures are working and are robust and they do exactly that, we're going to have companies here that are more readily able to identify potential issues and will in those circumstances be facing a very difficult decision, which is what to do with a finding of potential fraud. So Shula, can you perhaps sort of talk us through what the options are for a company if it does uncover potential criminality?
Yeah, I think the first question is, do you actually have a problem? So in order to establish that, your first port of call, frankly, is to instruct specialist criminal lawyers to assist you in an internal investigation. The question that you may be asking is, well, is it really necessary for us to do an internal investigation? The answer to that question is inevitably yes. In certain sectors, for example, in situations, there may be regulatory requirements to comply with. But failing to identify a concern that requires investigation and then initiate one where there may be a problem can expose companies to significant regulatory, legal, employment and reputational risks. More generally, good corporate governance is a key pillar of UK business legislation, as well as regulatory and enforcement activity. Directors owe statutory and fiduciary duties, such as the duty to act in good faith to promote the success of a company. So mitigating risks by having an effective compliance regime to mitigate those risks, but also undertaking an internal investigation where there may be a problem could be examples of discharging this duty. So instructing specialist criminal lawyers will ensure that the investigation is independent, it's objective, it ensures that any data collected is done so in a forensically sound manner in compliance with data protection laws, and that throughout the process of the internal investigation, most importantly, legal professional privilege is maintained. So it's going to be important to identify key individuals within the business who will form the client group, so those who will be responsible for giving instructions and receiving advice. So having gone through that process, have you still got a problem? You've identified one. The next question is, should you self-report?
The SFO has very recently updated its self-reporting guidance here, and it now makes it clear that the SFO expects organisations to self-report proactively and promptly, and that will strongly weigh up in favour of a DPA over a prosecution. And I think the new guidance goes so far as to say that where there has been a prompt self-report followed by full cooperation, a company will be invited to negotiate a DPA unless exceptional circumstances apply. So if you can tell us more about that, because clearly the SFO is keen to encourage self-reports and keen to sort of dangle the carrot of a DPA, and you mentioned 1.7 billion in fines, and so you can see why. But how important is that for a company? Is that the outcome we're looking for a company that's discovered a problem?
Yeah, whether to self-report is highly fact-specific and actually quite a complex decision. You've referred already, Anushka, to the updated guidance, which is dangling the carrot. But it's not guaranteed if you self-report that you'll get a DPA, albeit that the guidance, as you say, says they will invite you to negotiate, but there is the caveat of unless exceptional circumstances apply. The SFO are very keen for people to self-report. The new guidance specifically says that self-reporting suspected corporate criminal conduct, the SFO considers that to be a mark of a responsible organisation, and a knowing failure to promptly self-report such conduct impacts our assessment of cooperation and any mitigation, says the SFO guidance. So, the guidance expects it, and they expect organisations to coordinate with the SFO when investigating misconduct, including to ensure that nothing is done to prejudice an SFO investigation, Full and effective cooperation will include reporting it promptly, preserving, producing data, providing information to the SFO in a useful and structured way, identifying relevant material, providing the SFO with witness accounts and related materials. Importantly, the guidance also makes it clear that the SFO will consider a waiver of privilege to be a significant cooperative act. But as I said, whether or not to self-report is not a straightforward decision. Reasons to self-report include, as we know from the guidance, a very strong likelihood that a DPA will be available. It also allows the corporate to have the ability to control the narrative and the ability to demonstrate it has a strong compliance culture. Of course, the other big factor to consider is whether there is a risk that the SFO or other authority is going to become aware of the wrongdoing before a self-report is made. One thing that the current SFO director, Nick Efgrave, has made very clear from the start of his tenure is that he considers that there needs to be an encouragement for more whistleblowers to come forward by financially incentivising them, effectively taking a leaf out of the US book again. These potential changes are not currently in play, but are being heavily debated at the moment, and that could really impact a decision to self-report. On the other hand, the SFO does not have a significant track record of successful corporate prosecutions, or indeed, as Tom has already mentioned, successfully prosecuting those individuals who have allegedly been implicated. We mentioned earlier that there has been a change to the identification principle. So in theory, that makes it easier to prosecute corporates now, but there hasn't yet been a prosecution under the new widened identification principle. And of course, once self-reported, the sort of control over the process and the timelines shifts to the authorities. And of course, the self-report itself could trigger the need for a company to report that. If it's publicly listed, it can therefore trigger publicity or other regulatory scrutiny, which can impact share price, customer trust, and commercial relationships. So the decision to self-report is one that requires very careful consideration if you've identified a problem, and a delicate judgment on which specialist advice should be taken.
I mean, you've mentioned there potential reports to regulators or other authorities, and that's a really interesting thing that companies need to be kind of weighing into the balance, because the key word in the guidance seems to be prompt. And whilst the guidance sort of accepts that perhaps, you've got a suspicion, you might be allowed to investigate it before you're considered not to be prompt, that sort of sits a little bit jarringly perhaps with other disclosure requirements. And one of those that hasn't really been focused on is money laundering regimes, where there might be a need to think about what disclosures need to be made. You sort of deal with that, John.
Yes, so there's prompt, and there's also proactive, which I guess hints that there might be other people who report it before you do. And those decisions about the early stage and what to do with a potential problem are really key. And of course, the SFO is bound to incentivize, call us up as soon as you can, and don't in fact go to do first account, first interviews, unless you're doing collaboration with us. The reality, particularly when you consider those money laundering risks. So if you've got a fraud, by definition, fraud for the benefit of the company, if it's been successful, then there'll be a benefit of proceeds from that crime potentially in the company's accounts. And so when you get to a crystallized suspicion, then you've got a money laundering problem as well as what other problem you've got. So the case law is slightly helpful on this. De Silva talks about a vague feeling of unease. That's not enough. If you feel as though there may have been an offence here, but you're not sure yet, and you're still looking at it, there's some leeway. But once you've got a possibility which is more than fanciful, that the relevant facts are true, then you've really got to think about whether a pocket report needs to go in, and that could be an earlier stage that you're comfortable with. So it's something to keep a close eye on.
I mean, the money laundering side's interesting because earlier versions of the legislation had money laundering as one of the relevant fraud offences. And so had that version been implemented, we would have an offence coming in which also includes failure to prevent money laundering as an offence. That's not there. now, possibly because it's dealt with through a different regime. But do you think that's something that we might see in the future?
Yes, so the compromise is that there's an ability for the Secretary of State to make regulations that amend various things, including which offences count. So things that are similar to fraud can be added to the list at some point in the future, that is the schedule. And money laundering specifically in there is something that could be added by these regulations. And that would be quite a shift, I think, because currently what you've got is a suspicion-based regime, but it's a suspicion of individuals, and a failure to prevent money laundering regime would be quite different. But I think we need a whole new set of guidance, or certainly a big amendment to guidance before that came in. So not yet, but I think it's on the radar.
We're thinking about things then perhaps that might be on the radar. So the SFO has made some big statements about how it wants to be the first prosecutor to bring a prosecution for failing to prevent fraud. And it may well be the case, but failing to prevent bribery, which is what this is modelled on, was very much an SFO tool. It makes sense that it's an SFO tool. Failure to prevent fraud is potentially much, much wider. And so you can expect that there are other potential prosecutors very much in the ring, trying also to be the first to get there. The two that, I mean, one of them that you mentioned before was tax evasion, whether the revenue might be, but, can you say more about that and whether you think there are any other prosecutors who might be kind of chomping at the bit to
Yeah, so prosecutors and investigators, I suppose, because CPS will prosecute for a number of different agencies. So the thing about cheating the revenue being on that list is, confusingly, there's already an offence of failing to prevent the facilitation of tax evasion, which is essentially where your company or somebody on behalf of your company is helping somebody else to evade their tax, more often than not personal tax. But I think the situation that HMRC will be looking at with interest, because it really applies squarely to this new offence, is corporate tax evasion. So somebody, not necessarily a senior manager within the organisation, is doing things that dishonestly evade the company's tax. That would be something that HMRC is really interested in, and may, with the help of CPS, get there perhaps before the SFO. We will see, but I imagine there'll be quite an element of interest there. And the other thing that I think does come through, if you look at the history of the offence and some of the bits of the guidance where they talk about public sector organisations, is public sector procurement. Because if what you're doing as a company is dealing with the public sector, you bid for contracts, you run contracts, and the public organisation may consider that an unhappy outcome for them for various reasons, and they may consider it dishonest, then that's a potential use for this new offence. And I say it in particular because if you look back at the Law Commission, the first report they bring out, there are examples in that report from prosecutors of the sorts of scenarios where they think corporate criminal liability should be broadened for. And other than a handful about financial services, they're all about public sector procurement. And in the guidance, there's stuff about the NHS and their counter-fraud function, and stuff about the public sector fraud authority, which is looking, I think, mainly at the stats at the moment of how public sector organisations lose out from fraud. And if you think back to that objective test of dishonesty and the man or woman on the Clapham omnibus or wherever the bus happens to be going, there's a real issue there, I think, potentially, of prosecutors and investigators having their own ideas about what's dishonest and pursuing it as an investigation for this offence, and then potentially going for a DPA before any jury has a chance to look at it. Because those people on the Clapham bus are code for a jury, right? Ideally, you have a jury looking at this on a regular basis. In practice, DPAs, so it's investigators, prosecutors, and possibly quite a few public sector organisations will be looking at this from a view of, well, have we been ripped off? Has the public purse been fleeced?
I mean, that's probably a nice tie-in to go back to the discussion before on the regulatory sphere and how that might be used, because it's another example of kind of applying these ordinary decent man principles to niche sort of practice areas or industries.
Yeah. So I mean, the guidance is absolutely clear that the failure to prevent fraud offence will apply to traditional regulated areas. So environment is a key one. environmental crime was a key example in the guidance, as was greenwashing. So, making trumped up claims about your company having green credentials, that is something that can be pursued as a fraud offence under this new offence. And there's nothing at all in the Act which would limit who can bring a prosecution to the SFO or the CPS, and so others can bring other law enforcement. So the Environment Agency, for example, can bring failure to prevent fraud offences. In addition, there's nothing in there which would stop a private prosecutor from bringing an offence, and that really does open up this enormously. You can have activist groups, you can have activist shareholders who want to make a big play about a company overstating its green credentials, and they can find it. They can use this legislation to pursue companies, and it really does. I think the other point to note about fraud versus bribery is that the bribery was relatively limited, because in the number of investigation and prosecutions, one factor for that might be because bribery is, by its nature, a kind of a closed circle. You have someone paying a bribe and someone receiving a bribe, and potentially someone in the middle, and no one's very keen to talk about this. But if you've got a fraud offence, you've got people who have lost money, you've got commercial partners who aren't happy with what someone else is doing. You've got lobby groups, activists who aren't happy about how someone operates, and there's going to be lots of ways by which someone can launch a complaint, and, as we've just talked about, a number of different people that can actually bring an investigation and prosecution. So I think there's enormous potential for this being a really impactful.
And to be explicit about that, so you've got potentially complainants, alleged victims of fraud, which may be another company, perhaps a counterparty to a contract, potentially bringing civil claim and a private prosecution. So
I suspect, Anushka might answer this, but I suspect they'd have to pick one. I think it'd be difficult to bring a civil one. I don't know.
Well, I mean, you will frequently see circumstances where individuals or companies are pursued in parallel proceedings, civil and criminal.
Yeah.
And it doesn't necessarily follow that you must pick one, because one is designed for, say, compensation on the civil side, and the other is about justice and the pursuit of justice on the criminal side. But it's a big problem, isn't it, for companies, because you're opening up this multiplicity of venues. So you'll have, victims, for example, in the civil sphere, private prosecution. I mean, what's more interesting is if you've got private prosecution underfoot, but also a company's perhaps in negotiations for a DPA. Those two things don't seem to me to be as compatible as civil and criminal. But it's interesting because I wonder, do we think that sort of private prosecution angle is something that legislators didn't necessarily foresee? Because it does just open it up massively.
Yeah, I mean, it's interesting that you say that, Anushka, because what we see in the Bribery Act specifically is that in order to bring a prosecution under the Bribery Act, you have to have the consent of either the Director of the Serious Fraud Office or the Director of Public Prosecution. So a private prosecution under the failure to prevent bribery wouldn't get off the ground because it wouldn't get that consent. Now, there are no doubt public policy reasons why you need consent under the Bribery Act, given that inevitably they tend to be cross-border, there will be international relations at play, and there is a specific offence of bribing public officials. But we know that the failure to prevent fraud offence is modelled on the Bribery Act offence. So whether or not that was a deliberate, whether that was not included for other reasons, but it certainly would mean that, as we've discussed, a private prosecution could be brought. But if it were, whilst there was the DPA negotiation going on, in theory, it would make the DPA null and void, wouldn't it? Because you couldn't prosecute if the private prosecution was successful. Prosecute.
That must be.
I mean, I think the reality
so the
is.
DPA isn't in place yet.
Yeah, but I think the reality is that if that were that scenario, under the private prosecution, it is always open to the Director of Public Prosecutions to take over a private prosecution to drop it.
Yeah.
I think that's right. I think it's going to be one of those things that companies need to think about in that kind of period that you were talking about, Sheila, earlier, about what do you do if you discover something, thinking about who's going to be interested in this, who's going to find out anyway, and what might they do about it, and how do you manage those different forums. We've got about 10 minutes left, and so it might be a good time now to have a think about some questions. So some of them came in advance, and I can see that there is some on the screen. I'm going to do the ones that came in advance of this when people signed up. So one of them is that the guidance refers to preparation for emergency scenarios. What are these and how do we prepare?
Yeah, no, so the way that's phrased in the guidance makes you immediately think of COVID, and it is about not an emergency scenario for your company, it's about an emergency scenario in the broader context, perhaps on a national context. And I think it's one of those areas where it's a lot easier to say, oh, be prepared for emergency scenarios than to actually do it, because unless you're preparing for the exact same emergency scenario we saw in 2020, you need to have some imagination. And I think probably what I would say is, when you've done your risk assessment and all of that, is sort of, bearing in mind things as they normally are, whenever things fundamentally change about your business or about its context, you need to revisit it. So something, another epidemic or it's a natural disaster here, you'll need to think about whether the prospects of fraud have increased, whether the incentives are increased, the opportunities, if everyone's working from home, they're less easily supervised, that sort of thing. So easier said than done, but it's certainly necessary, I think, to have some provision in there about revisiting. Because what effectively guidance is saying is, this will not be an excuse. If everything changes and then somebody commits a fraud on behalf of your company, you should have thought that through. You should have thought through an emergency scenario. So I think that there needs to be a trigger for revisiting risk assessment at that point.
One of the other questions we received in advance is, does the legislation apply only to in-scope firms, or will it ultimately be scaled up to cover all businesses? Which I think is a question on the sort of the large organisation point, where it might go.
Yeah, I mean, the short answer is yes. There is scope within the Act to change the meaning of large organisations. The section allows the Secretary of State, by regulation, to alter the meaning, but it makes it clear that before doing so, he must consult both the, or she must consult both the Scottish and Northern Irish governments. Previously, the government had issued a fact sheet in relation to the offence, and they made it very clear that they wanted to avoid a disproportionate burden on SMEs and support economic growth. So that's, I think, the reason why it has been set at those levels. But what that did say was that they would consider changing the threshold if the offence does not have the intended impact. In fact, it said, quote, the impact of the offence will be kept under review, and the threshold at which companies are excluded can be amended in future through secondary legislation if necessary. So that's a wait and see.
I think that's why I think it was a political compromise, and this stuff about not wanting to have a disproportionate burden on companies, that can also apply to large companies. They picked large companies as being within scope, but others as not, because of politics. And you can bet your bottom dollar that if they get a chance to extend it, which they will do, they'll do their best to do it, and they just will do.
Is it politics, or is it that a smaller company is more capable of being prosecuted under sort of identification principles because it's less likely to have a sort of more complex structure?
Yeah, but the idea is they want to prevent. One of the ideas behind it is companies should be preventing fraud, and so if preventative policies procedures have value, then they have value to all companies, not just large companies.
It'd be strange if a change in corporate culture forever stopped at large organisations, but
I mean, that's a good link to the question that's on the screen, which is, I mean, it's segue-ish, but in terms of culture, does this mean that an effective internal audit can assist in a defence to evidence a culture where fraud is unacceptable?
That's something that can and perhaps should be done, and to try and ensure that your culture is one where fraud is not acceptable. And it's a good idea. Obviously, the problem would be if it doesn't work, then they'll say it wasn't good enough training, you should have done more of it, or something else went wrong. But I mean, it's a good thing to do.
An audit focusing on that question rather than the sort of existing audits, I assume.
Sorry, which question?
No, on failing to prevent fraud as a thing, because I mean, companies are already audited, right? They've already got standards, and the guidance talks about how there'll be an interaction between the existing standards and the other standards and this stuff. So, and I think there is something in there about, you know, just because your company is audited doesn't mean you're fine. But if the auditors look at this question, at these procedures, at this offence, then you know that should help.
Yeah, I agree. Yeah.
We've got just under 5 minutes. I'm trying to group things in terms of theme. Some of the questions are coming in relating to the position of individuals in all of this. And this kind of ties in what Shula said about DPAs and what you said, you know, in relation to heirs and the individuals not being prosecuted or not being prosecuted well. What we know, you know, DPAs are essentially a commercial agreement, which is what Shula said. And you can see why a company might want one, given those reasons. You can see why the SFO might want one. And what the mechanism does, it enables companies and the SFO to get together and to agree a statement of sort of quote facts that admits liability from the company's perspective, and it admits conduct that's been committed by individuals. But those individuals don't play a part in this process. And what we've seen time and time again over the last 10 years is when the time comes for those individuals to be prosecuted, those prosecutions are often not successful because a jury won't convict on the evidence. And that's the evidence that the SFO and the company have accepted as evidence of criminality. And I think the Tesco case was, the quote was, the evidence was so weak that it should never have been put to a jury. And so if the view is that, you know, it's the individuals here that are somewhat hung out to dry by these corporate resolutions, is the fact that there's a failure to prevent fraud offence, which widens corporate liability, going to exacerbate that problem rather than to help it?
Yes.
Yeah, I think it's going to multiply the problem because I think you're going to have more first amendment fraud prosecutions than bribery. And I think I would say that it's bad for the individuals. It's also bad for the companies. And the idea that the companies have done some sweet deal here where they can walk away with just a mere slap on the wrist, I don't think it's something that is not going on here. What companies are doing is they're paying enormous penalties and have suffering significant reputational harm for, in some cases, not preventing someone else from committing a criminal offence. And if those individuals are senior individuals, it's easier to say that's really the company's offending. But it could be the case that someone lower down the pecking order is committing a crime. The company has tried to do what it can to prevent crime, and yet they're on the hook for very significant fines. And so I don't think it is a sweet deal. And the reason why there's a difficulty for the companies is that they're in this impossible position. If they want to enter into a DPA, they've got to do it before the prosecution of the individuals. So they've got a very difficult choice to make. So that comes back to Shula's point about actually do we want a DPA? Or do we want to go for an alternative outcome here? That goes right back to the question about whether or not you self-report in the first place.
Whether you tackle whether it's actually fraud, which is something that you said. Yeah. There's one very last question, which hopefully is a very quick one. Are non-profit organisations, NGOs, etc., in scope if they meet the threshold? John?
Yes. Yes is the short answer for that. Yeah, there's a quite broad range of organisations. They don't have to be profit-making, they don't have to be corporates.
Well, I think we've got a minute left, so I don't think we can take anything more. But if we didn't get round to addressing any of the questions that you've submitted, we're sorry. Our details are up on the screen now. And so if there's something that you do want to ask any of us, please do get in touch. We would love to hear from you. So I think that all that's really left for us to say, or for me to say, is to thank Shula, John and Tom for their insights today, to thank Mondac for hosting us today, and all of you for attending and listening. And we really hope that you found it interesting and informative.